Welcome to Work Comp Talk, a podcast where we educate the injured workers in California. My name is Carmen Ramirez, your host, and joining me as a co-host is Bilal Qasim. Today we're going to be discovering a topic that is very trendy, and that is discrimination while you're on workers' comp or in general, also known as the 132A. Make sure you hit that subscribe button and the notification bell so when we upload our next video, you get first dibs. Bilal, welcome to the podcast.
Happy to be here.
Let's talk about the 132A, discrimination laws. It's a lot of things that people don't even know exist, but they do. We're going to be sharing some examples, so make sure you stay till the end of this video because there's a ton of information to dive into. Where do we begin?
I guess where to find it. So 132A refers to a code section of the labor code in California. And that code section in particular addresses discrimination in the form of retaliation for someone either pursuing or making known their intention to pursue a workers' comp case.
So getting fired because I pretty much presented a injury that happened at work, and then because I got injured and I told my boss about it and then I get fired the next day, is that considered discrimination?
Could very well be, provided you were actually fired and there wasn't really a reason for it, right? If you were fired because they caught you, smoking weed in the back room or something like that. It's probably,
it just so happened.
Yeah, then I wouldn't say that that's a 132A. But yeah, I think in 132A cases, there's generally kind of like there's a time continuum where it matches up, right? Someone was a great performer at work. All of a sudden, they get hurt. They say they want to report a work comp case. And then all of a sudden, you notice things start to change. The relationship between the employer and the employee starts to deteriorate. And things aren't the same anymore. And it's not necessarily just termination, right? You could be passed over for a promotion. You could have your pay docked, or you could have your pay significantly altered. Maybe you're making $25 an hour before, and your boss says, hey, you know what, I think we're going to be reducing your pay due to, quote unquote, budget cuts or whatever the hell it is, right? And so they make up some excuse to make you suffer and reduce your pay, and that's them kind of saying, you know what, F you for filing a workers' comp case. I'll show you, I'm going to, retaliate. And employers do that because workers' comp cases cost money. So it's like car accidents. The more car accidents you get in, the more your insurance premium goes up, right?
Right.
Same thing for work comp cases. The more accidents you have, the more the insurance is going to cost. And so employers get
I wonder
upset.
How much Tesla is paying.
Yeah, probably a lot. I guess they can afford it, But so employers treat it as like a personal attack, like, oh, you're going to cost me more money because you're filing this case. Or sometimes they just think that the case is made up, even if it's real. And they're like, you know what, this person's not really hurt. They just want a free ride. So, F them, I'm going to force them out.
That sucks. And that's a good example for you to share. Giving the fact that maybe there's kind of like those little petty shit that happen between your boss that you don't even realize it's discrimination, like you just mentioned, right? Like cutting your hours or just randomly changing your pay and you thinking, okay, well, maybe the company's going through some stuff, and you don't automatically say, I'm being discriminated against. So thank you for sharing those type of examples.
Yeah, and it's a fine line, right? Because, there's become a popular term, I think, in the last few years for I don't want to say little, but what people perceive to be, I don't know how to say it, either like unconscious or kind of sly ways of picking at people, called microaggressions.
Yeah.
Where you're like, hey, you know what? That shit was kind of rude. Did they... Or you know what, that made me feel uncomfortable. Did they mean to make me feel that way? Or did they intend to insult me? Or are they picking at me? And you can't really tell, and it's over time, And
it's like a fine line. Ugh.
Yeah, and it's like, well, is that really discrimination? Is it not? And so I always tell people, really we need to see something that's got some meat to it. You know what I mean? Like maybe your boss was cool with you before and would every time they saw you would smile and say good morning and how are you doing and have conversations, but now they just walk past you.
Right.
It's not illegal to not smile at someone, right? That's not discrimination. It could be if you're creating a hostile work environment, there's all this other stuff going on, but just a change in attitude itself isn't necessarily going to be grounds to file a discrimination case.
So now when you say you need to have meat behind this also embodies having that sufficient evidence that's going to support and back up your theory of being discriminated against, right? So
Yeah,
you can't
absolutely.
just say X, Y, and Z and not have anything to back it up.
I mean, you can, but at the end of the day, you go to trial, right? And in trial, it's either, well, there's an old saying, right? There's the truth and then there's what you can prove. And usually trial is some variation of that because the judge takes in exhibits and testimony, and usually you have two sides of the story.
Right.
And I know this became a popular term under the Trump presidency, but it's alternative facts, right? Where it's like, well, maybe it's this fact or maybe it's this fact, but there can only be one, right? And that usually what the fact that the judge has is usually some weird middle ground or some convoluted story of what either party thinks is really the true story.
Right.
And so the less evidence you have, the less witnesses you have, the less information you have, it just gets harder and harder and harder to prove your side of things.
Well, that's good to know. There are going to be cases where there is absolutely no evidence, but it's your word against theirs, and it's okay to also have that?
It is, but I've gone to trial on those cases. And I've gone to trial on cases where I had what I thought were good witnesses. I'm not gonna lie though, the defense attorney did a hell of a job tearing up those witnesses and cross-examining them and making them feel so small. And you see people who are like, yeah, I know the story, I'm telling the truth, and maybe they really are, but the defense attorney is so damn good at just chewing them up and making them feel insecure about what their story is and picking at every little detail that they have and just wrecks them in court. And so, really having that smoking gun, that indisputable fact, whether it's, an email or something, that carries the day.
Okay.
And so, we had a case like that. It's, story time. I had a gal, she was a residential property manager at a big apartment complex in the East Bay. And part of her job duties as a residential property manager, she was there on site, and she kind of helped manage the property for the tenants there, whether it's organizing repairmen to come in, keeping an eye on the premises, kind of cleaning up, making sure everything's squared away for the property owner. And in California, don't know about other states, but here it is legal to use free rent as part of compensation for residential property managers. So you might say, hey, you're going to be a residential property manager. I'm going to pay you $10 an hour, plus I will let you stay in a unit for free. And that's completely valid.
Right.
That is completely legal in California. And so that happens a lot, and because of the cost of rent here, that's actually a very popular way to get paid for a residential property manager. So Scal's working on the property. She gets hurt. She files a workers' comp case. Apparently the property manager was livid about the fact that she filed a work comp case, thought it was all bullshit, literally sends her a text message that says, we've won all these evictions, and unless you want to be evicted, you should come talk to me, and you need to drop your case, and we won't evict you. Literally threatening to kick this woman out of her home. And that is a case where it's absolutely discrimination. And in that particular case, I basically sent that text message to the defense attorney, and they just paid. They absolutely just paid.
How do you get yourself out of that one? I mean, the audacity of texting someone and saying, hey, if you drop your case, we won't evict you? That's horrible. Just because she was injured, and she legit was injured. So on top of her 132A, her discrimination lawsuit against this company, she also was injured, right?
Yep. And we settled her workers' comp case as well that was separate and apart for the 132A. So in workers' comp, you have you generally have two different attorneys for the 132A and the claim, because workers' comp claims themselves, they're considered no fault, right? And so they are covered by insurance. 132A cases are against the employer directly, and there's no insurance that covers that. And so you'll see in workers' comp case where there's a 132A component, there's an attorney usually for the insurance company, and then there's an attorney who represents the employer in that capacity.
Interesting.
And so I was dealing with the attorney for the employer in that capacity, and we made a demand for I think it was $10,000, and they paid $10,000. So it's a very expensive text message for that gentleman. But
I hope they learned their lesson, because people can't get away with it. And unfortunately, it's things that you see all the time. It just doesn't happen once. people think they can get away with certain things. For example, I've heard stories of people that essentially get injured on the job, and because they reported the injury, they get fired right away. Or they just all of a sudden, start treating them really, really wrong. There was this guy who once told me the story of working in a specific job industry where there was freezers. And because that person was injured, all of a sudden got dumped all the responsibilities to work inside the freezer constantly.
Yeah.
And that is insane, you know? It's like things like that happen all the time.
Yeah, sometimes it's really aggressive, where it's just like that text message or like changing of the job duties that it's like super extreme. Like we see sometimes where people get hurt, they report the claim, and all of a sudden they get reassigned a different shift. So it's like, oh, you were a day shift person, now we need you for night shift or you're fired. Or hey, we know you have kids and so you work a split shift, we can't offer you split shift anymore.
Damn.
And so they're really slimy. I swear, they do everything just to mess with people. And sometimes it's that, or sometimes it's really kind of, like I said earlier, these microaggressions, these little ticks and picking at people.
Right.
And it's every case is different, but unfortunately we see it a lot. And it's not just, this one residential property manager, it's giant companies that do it too. Mm-hmm. It happens all the time.
So what is one of the things that someone can do proactively to kind of mark the checks or the check marks and say, you know what, this is exactly what I'm thinking it is? Because like you said, those microaggressions can be a bit, I used to have a boss, he was bipolar. One day he would smile at me, the next day he wouldn't. And he would not smile for an entire month. But that's not necessarily being discriminated against because they don't have to smile at you.
No, maybe he's just bipolar towar's everyone.
Exactly. No, and he was literally to everyone. But what are some of the things that someone can be like, you know what? Okay, this marked, this I'm crossing off the list. Like, I actually do have a case. Would that then be best to just, hey, have this conversation with my attorney? What do you think? Or?
So I always tell people, keep notes. Keep notes, keep notes, keep notes. I can tell you, hey, I had a conversation with Bob 2 weeks ago at, 6 a.m. That's great. Maybe someone won't believe me. Mm-hmm. But if I have a note or an email that says, hey, Bob, summarizing our conversation today at 6 a.m. and it's there, right? It's memorialized. No one can dispute the authenticity.
Okay.
So I always tell people, keep notes. If you're communicating about the way you've been treated or your injury, or whatever it is, put it in writing. Instead of having a conversation with HR, send them an email, send them a confirming letter, whatever the case is, just document, and document. Because that's really the key in bolstering your own credibility as a witness, just in case, and the likelihood that they're going to have someone who's going to be there that's going to say, no, everything that guy said is BS, he's lying, he's just trying to make stuff up because he wants to get paid. And I see that happen a lot, unfortunately.
Wow.
So the better you document your interactions, the better off you'll be in the event that you have to actually go to trial.
This happens a lot. Give me some examples of some of the things you've seen in the law firm when it comes to connecting a work injury and being discriminated against. We already heard about the story about this lady who was going to get evicted because she was reporting her injury. What are some other examples?
Probably the most common is what they'd call, I guess, disparate treatment. Meaning that a corporation or an entity has certain policies and procedures. And depending on who needs those policies or procedures, whether it's accommodations or otherwise, the company administers the policy differently depending on who it is. So you could see someone who says, maternity leave, for example. Let's say someone's going to go out on maternity leave and they are on a workers' comp claim. They have a leg injury or something like that. And the employer's policy normally is that they give, 6 weeks of paid maternity leave in addition to whatever legally unpaid protected leave someone gets. And then all of a sudden, let's call her Jenny. Jenny comes along and is like, okay, well, I'm injured. I have workers' comp right now, but I want to take my maternity leave, And then the policy is now, all of a sudden we just changed our policy. We don't actually offer paid maternity leave anymore. Oof. Or, you haven't been here long enough for paid maternity leave, even though there's nothing against that, right? Or they make up new policies or they change policies or administer it differently because that particular person is injured. And they try to be sneaky like that because they're like, this is maternity leave. It has nothing to do with workers' comp, so no one's ever going to think that we're screwing with this person, right?
Right.
And so that happens a lot. That happens a lot. Or you see before, let's say, company policy is that annual reviews are the norm, right? You're supposed to get a review every year. Well, all of a sudden you file your workers' comp case and the company starts saying, you know what, we're going to start doing quarterly reviews. And they start just hammering you for everything that you're doing wrong. And that was something they didn't before. And maybe they're not doing that for other employees. That comes up a lot too. They try and ride you to like force you out in a lot of ways.
Yeah, like, hey, you're not doing a great job as you used to before. Now that we're checking in on you quarterly, we're realizing that because you lost your arm, you're not as productive in the packaging system. Like you're down to half of what you used to do when you had 2 arms.
Yeah, or maybe you just always sucked. And like, no, and I'm saying like maybe you were always like a crappy at your job, but they were cool with it.
Yeah.
And now all of a sudden, because you have a workers' comp case, all the things that they ignored for whatever 5-10 years are, it's a problem now, right? And so that in and of itself could be considered work comp retaliation under a 132A claim.
This is insane. I mean, these little details, and it's not necessarily something you would want to dive into alone. Like, if you're just that type of person that says, you know what, I got this, I'm going to go onto Google, research some of this stuff, I'm already handling my case on my own, and now I want to, on top of my workers' comp case, kind of figure out this whole discrimination. These are things that you need to really know the fine print for in order for you to become successful. What are the odds of someone actually filing a discrimination lawsuit against someone on their own? From it being positive.
I mean, probably you're not going to have a good outcome, I think, unless you really
know what you're doing. Understand?
Yeah. I think you really have to understand the nuances. And there's a couple, specific ones. For example, workers' comp for 132A claims, the damages are pretty well defined, right? It's a max $10,000 penalty, which is what I asked for on that case that I just described and we got.
Okay, so I can't get over $10,000 for discrimination.
No, but you can get back pay. If you're terminated. You can get reinstatement to your old position. Not many people ask for that because who wants to go back to a shitty employer?
I know, right?
And you can get costs as well, and reinstatement or benefits that are due to you as well. So there's a bunch of things that you can get, but just like as a monetary award, you're not going to get your job back plus back pay and punitive damages in like $10 million or whatever, right? That's just not how it works.
Interesting.
But there are kind of parallel civil cases that oftentimes run hand in hand with 132A claims. So we have the California Fair Employment Housing Act, and we also have Americans with Disability Act. And those are both different avenues to pursue cases for things like protected class-based discrimination. So you have things like discrimination based on sex, gender identity, race, religion, and also disability.
Right.
And so disability discrimination under Fair Employment Housing Act or Americans with Disability Act is different than a retaliation claim under 132A.
Wow.
And it's because there's no protections under FEHA or the ADA for workers' comp retaliation. There's no cause of action.
Right.
It's the exclusive jurisdiction of the Work Comp Appeals Board. And so understanding the nuance between those and understanding, hey, do I have a 132A claim here? Or do I have a Fair Employment Housing Act claim? What is it? Or do I have both?
Yeah.
And we do have cases where there's both. We have cases where there's just a FEHA case. And so I think you really have to understand the nuance there and understand what's the better avenue for me to recover, if at all. The damages in Fair Employment Housing Act cases are far more substantial than in a 132A claim, for example. But they cover different things. You have to understand the nuances. One's in civil court. One's a federal case, one's a work comp case, and unless you understand how to navigate that, as well as what's required to actually proceed in those cases, the paperwork, the complaints, you have to get a right to sue letter from the DFEH. It's not something that's just like, oh yeah, I can read online how to do this and do it. It's complicated. Sometimes it's right there in your face, sometimes it's not.
Yeah, talking about right there in your face, story time. Now it's my turn to tell a story. So there was this company who was seeking to look for people to hire to work for a specific job. And they accidentally posted a little bit too much. And this is one of the stories where it's too much in your face. So the person that actually ended up writing the job description for those search engines where you look for a job added the notes of the internal section of the company, which were specifically hire a white person that is from this age to this age. And all of that was out there in the job description, in the posted job description. And of course, someone caught it, and it was like, became a really big case. And it was insane, the fact that all those details and the fact that it even happened. How does the company say, oh, hire only white people, hire only from this age to this age, they have to live within a certain distance from the company? Like, shit like this happens. It's real.
Yeah, and I mean, you said, how does this happen? No one knows. Like, it's just, it doesn't matter. It can be a big company. It can be a small company. Sometimes they're just stupid people doing stupid things, and it comes up. And like you said, sometimes it's right there in your face. Other times it's not. And when it's not, it can be really hard to fight that battle. And that's why it's really important that if you're really going through this and you're not sure, that you hire an attorney.
Yeah, like Bilal.
Like me.
Have any more questions? Make sure you hit the comments below, and we'll definitely get back to you as soon as we can. We'll catch you guys on the next episode. If you're new, make sure you hit that subscribe button. We'll catch you on the next episode.